Next speaker is Mike Burns, our Chief Legal Counsel, who's going to give us a primer on open meetings and maybe a little parliamentary procedure stuff too. Would you like the mic, or do you just want to show it?
Looks like a long way back there. Can people hear in the back?
Yeah.
Sometimes. Depends on the speed.
Okay, well maybe I'll try without the mic. Does this sound pretty good? All right. Okay, well, good morning, everybody. And before we get started, I just want to thank everybody for attending and taking time out of your days and your busy schedules to be here. I really think the more you know, the better a board member you will ultimately be. The other one thing I want to say is that what you're going to be hearing today are a lot of legal concepts. And I don't think many of you are also attorneys. You are experts in your professions, but you're not attorneys. And so certainly I always encourage you, if you have questions, talk to your executive director, talk to your legal counsels, talk to whatever staff people you need so that you make sure you get those questions answered. We want to make sure that you have the ability to be acting correctly. Another thing I always point out to people is that ethics, and I heard, I know you had some ethics earlier. There'll be ethical issues in terms of the open meetings law because it's an ethical violation to violate the open meetings law. Ethics are not always intuitive. I may think you are all ethical people. You may all truly believe you are ethical people. Yet the way the law is written, it doesn't presume you're ethical. It presumes there are people out there trying to get around ethical issues, trying to evade the intent of the law. And so, always keep that in mind. Ethics simply are not intuitive. We all think they are. And when I first heard that, I thought that was kind of a strange statement. But when you think about it, that's really true. And then when you look at how the law is written, it doesn't assume you're ethical. It assumes that people are out there trying to potentially commit violations. So, whenever you have ethical questions, if you have an issue, again, talk to your executive director, talk to your legal counsel. All right. The first thing I'll be talking about is open meetings. Okay. Turn on. And this is language from one of the statutes. I'll give everybody a chance to read that. And not only is that wording in the statutes, but this is a paraphrase of a subsequent section of the statutes. Open meetings laws to be broadly interpreted to promote the policy of openness. And I've seen over the years, whether it's open meetings or public records, courts truly do take that to heart. If you have a close question or something that's unclear, a court will likely prefer an interpretation of the law that favors open government. And the same things apply, the same type of concept applies to open records. Courts disfavor interpretations that would facilitate the evasion of the policy of openness. Now, open meetings law applies to meetings of governmental bodies. Governmental bodies has a definition, but for purposes of today, we won't go into all the other definitions. All the boards, all the councils, all the affiliated credentialing boards, all the sections are government bodies. There are two important concepts you have to convene. It also has to be for a purpose that relates to your duties. And that's set out in one of the key cases, the Showers case. It talks about the purpose requirement and the numbers requirement. Now, first we'll talk about purpose. I just skipped over those slides because I know we're in kind of a tight time frame here, but the purpose is broad. It's preliminary decisions, it's discussion, it's information gathering, and you don't even have to be together interacting to be engaging in one of your purposes. So definition of purpose is very broad. Now, how many members does it take to constitute a meeting? Well, it's a sufficient number to determine a course of action by the body. And a warning down at the bottom, that may not even be a quorum. Clearly, if you've got a quorum present, you have enough to determine a course of action. So, that sufficient number would be the affirmative number to pass a motion, or the negative power to defeat a motion. And that later concept, the negative power, is called a negative quorum. Okay, you must also convene for there to be a meeting. But that's not limited to face-to-face gatherings. It includes any situation where you can communicate. So, some obvious situations would be telephone conference calls, video conference calls. You can communicate verbally in an instantaneous way. And as a practical matter, that's like being together in a room. More recently, there are other forms that you have to worry about. Email, electronic discussion boards, instant messaging, or social networking. Arguably, you could have a meeting on Facebook. So that's something to be certainly aware of. And maybe I should have used stronger wording here, that electronic messaging may or may not implicate the Open Meetings Law. Caution is advised. It definitely does, I think, implicate the Open Meetings Law, and you can't do that. If there are communications with the quorum of the board like that, it is a meeting. And again, if you're not physically together, the key question is, does this resemble a face-to-face interchange? Now, another thing to think about is the concept of a serial or a walking quorum. And this can occur when you have a number of small meetings with different parts of your group. And it can even occur if you tell somebody to go tell somebody else something. And it could be you can't use intermediaries. That still would be a walking quorum. Here are the elements of a walking quorum. Series of gatherings, smaller than the quorum, where you agree to act uniformly, and ultimately it encompasses a sufficient number to control that body. It's intended to prevent the attempt to circumvent the law. And without going into war stories, I've had different board members wish they could have lots of communications and talk things out ahead of the meeting. But you can't do that. You can't all come to agreement before on certain items before the meeting. That's why you have public meetings, public notice of the items to be there, a chance for everybody, not just those in that special loop, to be able to speak. And that when we talk about rules of order, that's kind of a key concept. Both the majority gets an opportunity to have input as well as the minority. Again, the practical tip, things like walking quorums are complicated and fact-specific. If you have questions, talk to the legal counsel or to the executive director. Meetings don't necessarily include social gatherings. However, you should be aware if more than half of you are present at some gathering, then there is a presumption, and this is again one of those situations where the law presumes that there's a problem. And there's a presumption that you were there for government business. Just going back to that slide, I just do have one more comment. There have been situations, for example, where a board meets or a city council meets, and then they all go out. In this case was old, they call it a lounge. They all went out to a lounge after the meeting. Well, what do you think they talked about? And a quorum was there. That was a meeting, but it wasn't publicly noticed. And so that would be a problem. And the same thing, we have situations where board members attend or we want to have a dinner, for example. What we sometimes will do in that situation is put out a notice saying a quorum of the board will be present at such and such. Board business will not be conducted. So if you ever wonder why we do that, that's because the law assumes that if you have more than a quorum present, you have a meeting. Okay, every meeting must be preceded by a public notice. That must be communicated to the public. And we, of course, put it on our website. It must inform the public of the time, place, date, and subject matter of the meeting. And it does require some level of detail. And there are some things that we'll go into in the next slide or two that help set that out. But you have to look at a few things. We can consider the burden of providing more detail, the degree of public interest, and whether the subject is non-routine. And as boards, you deal with some routine things, but also many items that are of great interest to the public. Some terms should not be used. Greg is sitting here, he knows these terms too. Old business, new business, agenda revisions, miscellaneous business. That doesn't tell the public what's going on. To the extent you can clearly tell the public what's going on, it should be identified. If a closed session is anticipated, that should of course be noticed, as well as what's going to happen in the closed session. Notice must be given in a timely way, and I can tell you that there's a very high burden to do a notice in less than 24 hours. I'm probably never going to approve that. You at least need that, and we normally put the notice out even the week before. I think the notice is generally put up on Wednesday for meetings the following week. You can't notice groups of meetings. They have to be noticed separately. And then there's some specific things. An open session, for example, I think some of the boards have run into this. That's not the slide I wanted, but if you have an open session, you can't go into closed and go back into open unless you've noticed that. You can move to something later in the day. If you adjourn or recess to another date, you need a separate open session has to be in an accessible place. Should of course be in the state of Wisconsin. where you're supposed to have adequate room size and acoustics and have it physically accessible. Skip over these. Actually, we'll go back to that. If you have an open session, we should have an open door. It should be unlocked. If by chance you have to be moved to some other part of the building because of room conflicts, you'll have a sign on the door saying it's an open session. Then you're in compliance with the law. The public has a right to attend and to observe. There's nothing in the law that requires the public to be able to speak. That's not a requirement. However, you can put on your agendas public comment as an agenda item, and you can have a period for public comment. I think most of the boards do that out of respect for the people who are attending who may want to say something. During that time, you may receive information. You can discuss it, but then I normally warn boards, you should keep that discussion relatively short, and if it's really something you want to take up, you put it on your next agenda. But what you can't do is take some type of formal action. That really has not been noticed, and other people wouldn't have an opportunity to come and speak. Another thing that's come up a few times for boards that have things of a lot of interest, you have an obligation to let people photograph or record. There's no prohibition on people recording what happens at a board meeting. However, you do have the ability to make sure it doesn't disrupt the meeting. So we've had situations, I know of one board in particular, where we've allowed microphones to be placed at the head of the table so they could get recording, where cameras could be placed in the room, but it can't be such that it interferes with the ability of the board to do its business. Okay, voting. No secret ballots except for electing officers. Any member may require a roll call vote. Motions must be recorded and preserved. Voting records must be made available to the public. The open meetings law does not require that you actually keep more extensive minutes, but for various groups that might be required by other provisions. Now, as to closed session, meetings should begin in open session, but to go into closed session, you have to make a motion. And I think all of you are used to that, reading the long phrase of purposes, and that's required. And the vote of each member must be recorded. So that's just not a quirky thing we require boards to do. That's specifically required by the law. The thing you read to allow the move to closed session has to set out the statutory exemptions and the nature of the business to be conducted. We have a question.
That's fine. Can you explain why we have to disclose when we go into closed session? We are going to deliberate over an infraction of in our case, pharmacist, and it seems to be it's public, and then it's in the agenda, it's in the meeting. It seems a little, I don't know, unnecessary sometimes. A lot of times there is a major infraction, but sometimes it's kind of borderline, and it seems like public flogging in a way that may be necessary. We have to list names on it. Is that a requirement on this slide? Making myself clear?
No, I think I understand, and I'd have to look at your specific agenda and the whole thing. But generally, the law favors more information and a good description to the extent possible what you're doing in that closed session.
And it mandates names.
And I think it'd be a problem if you just had a general description considering disciplinary matters. That probably is not going to be enough. Now, another important concept, if you're in closed session, you have to limit your discussion to the specific business for which the closed session was authorized, and not take up other matters. I know you, sometimes boards will go into closed session, all of a sudden they want to start rehashing things that happened in open, or think they're in closed and now can talk about anything because the recorder is on. And that can't happen. When you're in closed session, you're supposed to be staying to only those topics identified as the topics for closed session. That's why you went into closed session. So anyway, many boards don't do that, but I've seen situations where it's really tempting to want to go and rehash something that occurred in open, or to now talk about other things. We've also had questions about who can attend closed session. And that is largely in the discretion of the board. It's who you think is necessary. So that's why staff will attend. Sometimes we've had people come in for training who will be working with that board in the future attend. The board has the ability to make decisions about who will attend that closed session. The specific reasons for going into closed session are identified in the statutes. And all the things that we do in closed session, such as considering disciplines, some licensing issues, certain denials, that's all authorized. Consulting with legal counsel, those are all specifically authorized. And when that list of statutes are read, those are all included in that list. There's a little difference in some of the case law on voting in closed session. There's a case that says if it's integral to handling the matter, you can vote in closed. But then there's a more recent case that says you should vote in open. And I think all of you know that most boards do certain things in closed and then come into open session and do a vote. And as you'll see in the last bullet point there, that is what the Department of Justice, who is one of the bodies that can enforce the open meetings law, as we'll talk about later in enforcement, DAs can enforce it as well as the Department of Justice. They recommend a vote in open session. Again, you can return to open session after a closed session, but that should be noticed. If you've done all your work, you can adjourn right from the closed session. Okay, enforcement.
Mark,
Yes.
just one question on the last slide. If you notice it to go into and then back to open, can you decide not to go back into open? If it's noticed the other way?
I would go back into open if you've noticed it that way.
Okay. Yeah. Thank you.
Yeah. There's just nothing in the law that requires there to be another. You could have your. But if you're going to have to go back into open to vote on anything, you're going to probably be going back into open anyway. Okay, enforcement alternatives. Violations of the open meetings law can be enforced by the local DA, by the Attorney General, or by a private citizen. If it's a DA, it would be in the county where the alleged violation occurs. So here it would be the Dane County District Attorney. They must receive a verified complaint, written, signed, and sworn, and that's in the law. Now, the Attorney General can also enforce violations, but they tend to only want to become involved if it's statewide matters. They normally prefer that somebody go to the local DA. However, if a DA fails to act within 20 days, the person who made that complaint can bring an action, enforce the open meetings law. And I'll just note, if they're successful, they can also get their attorney's fees. The penalties for open meetings violations set out there at $25 to $300 per violation for any member if you knowingly violate the law. Attends a meeting or otherwise violates the law. I wouldn't want to be going here, but if you act in good faith on the advice of legal counsel, you probably won't get in trouble. But that's not, we don't want to be cutting it too close to the line. Usually with ethical things, I never suggest get close to the line. You want to stay away from that line. But if you're acting in good faith, relying on legal counsel, you probably wouldn't be found lying. There's also another enforcement remedy. If an action is taken at a meeting in violation of the open meetings law, that action may be void. I did see a case where, in fact, that was a situation. In that unfortunate case, that body had apparently been meeting illegally for 3 years. So they kind of had a track record of violations, but the action they took was voidable. Courts don't like to go back if bodies are acting in good faith and void things, and that probably won't happen. But where you have blatant situations, you could have board actions be voided. Two things here. One is questions. The other thing is, it says portions copied from the DOJ open meetings outline, which is on their website. They have a much more extensive outline on their website, and portions of these slides are from that. They gave me authority to use them and I guess to modify them, but not represent it's a DOJ presentation. So, in any event, any questions? Yes.
Is it a violation of open meetings law for board members to email other board members to solicit them to vote for them when there's elections coming up? They just send it, one-to-one versus. That just didn't seem like it was quite right to me. That was
Yeah,
versus,
and that's something I'm going to have to check on, because I know that unless one of the legal counsels has any advice on that, I know that issue came up, and I did look at that a few years ago as to whether that's board business and whether that's been carved out as something that does not fall into those other restrictions. I don't know, Rick, do you remember anything like that? So I can't say yes, but right now that's okay. But it's something I would have to get back to you on, because I think there's something carved out for that type of communication in some AG's opinion somewhere. But I did not read it in preparation for this meeting. Okay, yeah, Greg will make a note of the question so we can get back to you on that. Yes?
Just, and I'm not trying to play stump priest here, but if you have, as an example, you have 5 members of the board, 3 of which it would be a quorum. So technically, because they could convene the 3 of them, therefore 2 of the people on that board talking about something could be a violation, because you could have a meeting with 3, 2 would be a quorum of 3. I mean, I've seen this discussion before, and I'm just wondering,
Well, you know,
how far
With-
can you carry this?
with the small boards, it becomes particularly problematic.
Right.
You know, where arguably 2 people could be certainly a negative quorum for certain types of actions.
Right.
You know, if you're talking about, if the 2 people got together and talked about, on a 5-member board, about an issue related to suspending or revoking a license, that'd be a problem. But with the small boards, we run into that even with the issue of board chairs voting. You know, there are just all kinds of problems when you have the very, very small boards or sections, because these laws apply regardless of size. Any other questions? Yes.
We get our agenda and appropriate information on a Friday, and our meeting is on Wednesday. And it seems like there might be 10 or 15 items added to the agenda. Can they legally keep adding up to that 2-hour time posting before the meeting? Or is there a time where we can cut off additions to the agenda? People can say,
Right. And that's something, you know, to work out with your specific executive director, but there has to be 24-hour notice. So I don't know, Greg, if you're aware of any situations where we haven't had at least a 24-hour notice. Since you've been, I can't remember anywhere we've approved 2-hour notice. So there'd be a time frame where what's on the web would be updated. And normally it's going to be 24 hours. In less than 24, we're not going to approve. Yes.
If a board was going to conduct business via conference call as an official meeting, how does the logistics of making that open to the public work? Is it that any public member can call and listen, or how do they facilitate that?
Yeah, and I think and maybe Greg can answer this better than I can, but I know one thing we've done is you have a room available where there's a speakerphone, and there would be a place the public would come and sit and where staff set up like it's a meeting and they do the work, and somebody could come right in and I believe that's what they're doing now.
Yeah. So in your case, I mean, literally, we'll have, in some of our, this happens quite frequently, so you'll have Tom, or in your case, Dan Williams, you know, literally sitting here at the table with the Polycom unit in the middle, with, everybody in the go-to meeting, teleconferenced in. You can hear everything in here, and so that's the individual's venue to come and listen. Everything happens. It's set up just like a regular board meeting.
Okay, any more questions? All right. Okay, the next presentation is on parliamentary procedure. And we saved this really interesting presentation for the time right before lunch, because we knew that if it ran over, nobody would be concerned. We'll just work right into the lunch hour on this one. But I wasn't worried about the time, because I do not plan to go through this whole outline. It's too specific and detailed in some regards to go through this whole thing. These will be on SharePoint. The other important thing to note is I am not recommending boards adopt Robert's Rules of Order. I collected 4 or 5 copies of them over the past couple of weeks. Every version's a little different. There's a lot in there that's contrary to the statutes. In terms of quorums and what you need to do certain actions. And so I'm not suggesting boards adopt that, but in looking at it, well, another thing I'd say, I've been to many board meetings. I think a lot of the important principles actually are met by how you function. And we'll go through some of these basics in some of these slides. So to a certain extent, I'm not sure we have a problem that needs to be fixed. And I'm not sure that adopting Robert's rules would be a way to fix it. So, with that said, let me start this presentation. Well, we might not need Robert's rules. I think you do need some kind of rules or conventions by which you conduct your meetings. And ideally, however you do it, should provide for fair and orderly meetings. They should promote the majority's right to decide. The minority on any issue should have the right to be heard. And absent members should also be protected in terms of notice of what's going to be happening at the meeting. Robert's rules were written by General Henry Robert in 1876. It's kind of interesting. He presided over a meeting at his church, and apparently the meeting got out of hand. And so he was greatly embarrassed, it says. And so he saw the need. It compelled him to write this lengthy book with fine print. So it must have been pretty embarrassing. But it's also important to note that over the years, and with all types of other different bodies, like the British Parliament, for example, there have been rules of procedure that existed long before this. And just some general comments. Usually, out in the real world, entities have the power to decide how formal they wish to be. We, of course, have some statutory requirements that we can't ignore. Bylaws, rules, things like that are set by the body. And I reiterate here, well, one other comment about that. Oftentimes, smaller groups can be less formal. The larger the group gets, there's probably the greater need for more formal rules and ways to proceed. And again, I note, I'm not recommending a board go and adopt Robert's rules. If they are adopted, it takes a few meetings to change that. And then there's an interesting quote that we'll come back to. People who enjoy meetings should not be in charge of anything. And I read that and I wasn't sure what that meant. I was concerned because sometimes I enjoy meetings. So it was kind of disturbing. But but I decided there's a way to read it that's better. We'll revisit that. Okay, the basics. And I think most boards actually try to emulate this. We have the rules to make the meetings flow smoothly, to help people work together. That's what we're trying to achieve. And that's what we hope at the end of the day you've done. We also want all members to be equal and to have equal rights. Therefore, every member can make a motion, and of course, motions should be clear and precise. And then the big one, motions should be fully discussed with each member having an opportunity to speak. And to a certain extent, I always view that as falling on the board chair. When you conduct a good meeting, it's not just the people who want to get out there and talk. Bring out some of the board members who don't speak, who are sitting there maybe not in agreement. Maybe ask them what their thoughts are on it. So it's important to have a good meeting, to have everybody talk, those for motions, those against them. And that's a principle I hope we always abide by. Only one person should speak at a time. And only one matter may be dealt with at a time. I've seen one or two situations where suddenly you have a couple of motions on the floor and amendments flying around. You don't know what you're dealing with. You deal with one motion, one amendment to that motion at a time. And there's a certain order to which motion should be taken up. Finally, the majority vote rules. Those are kind of the basics. And I have to find my sheet of paper here. So, going back to that quote, again, I'm not sure about it, but I prefer to think of it, people who run open, fair meetings should be in charge. So, and that's what we should be trying to achieve, good, open, fair meetings where all the members have an opportunity to participate and share their ideas. Now, because I knew we'd run out of time, I can tell you that on the website you'll find a sample process that are entitled the DSPS Rules of Order. And we're not going to go through these, but it covers kind of how it normally proceeds, including quotes of what happens. We've got a discussion of motions. There's quite a bit there, so take a chance to read through that. How you make amendments, the ability to reschedule or postpone, how you can refer things to committees, how you change a prior motion, information about voting, and then adjourning. That's a lot of detailed information. It's kind of a brief outline of how we tend to go through the process. It would be especially helpful for board chairs to probably go online and to read that. It's kind of a simplified version. And I would also thank Pam Stock sitting in the back, who gave me a lot of good information for this, and an outline which she probably recognizes was transformed into a PowerPoint with some minor changes. So anyway, any questions on rules of procedure? Okay, well, I encourage everybody, especially the chairs, to take a look at that sample process. It kind of, or for new board members, it kind of walks you through how we go about it, and it also accounts for some of the situations where statutes control what you do, because if you're sitting in a situation not where you're completely controlling how your meetings occur, many of the things are governed by statute.
That's accessible on the DSPS's main webpage. Is there a link?
It's going to be on SharePoint.
We'll have it up on SharePoint.
I think all the presentations, as I understand it, will be available on SharePoint. And like I say, if anybody's interested in open meetings or public records, there's good information on the Department of Justice website, a more extensive discussion of those issues. All right. Well, thank you very much.
Hey, nice job. Like Mike said, all the resources will be up on SharePoint that you're seeing today, including videos. Once they're edited, it might take a little bit, so bear with us. But we'll make, if your board isn't on SharePoint, talk to your executive director, and we'll get the resources to you somehow into your hands. So it's time to break. To kick off the afternoon, we wanted to give you a quick primer on the Division of Professional Credential Processing. And we have Caroline Brewster here, who's kind of our jack of all trades in that division, to talk to you about it.
Thank you. I'm going to try without the mic. Can everyone hear me in the back? You need the mic? Okay. Okay, hello. My name is Carol Ann. I work in the Division of Professional Credential Processing. I'm pretty much just going to read from the slide. If you have questions, I'll take them at the end. So, our division staff roles, we have a division administrator who oversees division operations, division supervisors, they oversee operations within the units of the division, licensed permit program associates, or LPPAs. They review the applications, they issue credentials and titles, they provide complex customer service. Division paralegals, we have two. They serve as liaisons between the LPPAs and the credentialing liaisons of the examining boards, or the boards themselves. They also draft denial letters and requests for more information. We have office operations associates. They provide frontline customer service, credential renewal service, and records retention processing. We also have program and policy analysts, of which I am one. We analyze and implement statute and code changes and standardize division procedures. So primary functions of the Division of Professional Credential Processing, we issue approximately 150 types of professional and MMA or boxing credentials and 84 types of trades credentials, averaging 35,200 new credentials annually. We renew professional and trades credentials on annual, biennial, or 4-year cycles, depending on the credential, averaging 192,300 renewals annually. We process verification requests of Wisconsin credential holders who are seeking reciprocal credentials in other states, and we provide manufactured homes titling services, averaging 12,600 transactions annually. We maintain databases for all credential holders and provide license lookup services via our website. We process requests for duplicate certificates and replacement titles. We coordinate with other state agencies regarding credential denial or revocation due to delinquent taxes or child support delinquency. We perform application review, approval, and denial for direct licensing credentials. Those are credentials that don't have an examining board. We work with examining boards and credentialing liaisons based on authority set by statute, rule, or board motion. So our interaction with boards may vary based on the authority. Working with the examining boards and liaisons, the LPPAs review applications and refer to delegated authority to determine further action. For example, if the LPPA themselves can make an approval, if a paralegal can review, or needs to be sent to the credentialing liaison or the full section or board. As needed, application files are forwarded to the paralegal for review, approval, denial, or request for more information, or to share with the credentialing liaison or section and board. Coordination between the paralegal and credentialing liaison is done outside of board meetings using SharePoint and/or email correspondence. Working with the boards via agenda. If an application review by an examining board or section is needed, the paralegal submits an agenda request item for closed session. The paralegal may attend closed sessions in order to answer questions or take notes regarding board decisions. Once motions are published, the paralegal will take appropriate action, such as draft a denial, request more information, or return to the licensing specialist for the issue of credential. That's all I have on the slides. Does anyone have questions? Okay, thank you.
Hey, thanks, Carol Ann. And she kept us way under budget on time, isn't that great? Next, Josh, the man with the plan behind the desk here, who's been operating this all this fancy technology that you see, is going to give us a primer on SharePoint. Some of your boards are up on SharePoint. I know generally our trades advisory councils, if anybody stuck around for the afternoon session here, are not as of yet. But by and large, most of the other boards are. So we've had a lot of questions come in. We did our board and council and committee member survey late last year. There were a lot of issues raised just with the transition to that technology, going to SharePoint board meetings. So Josh is going to kind of start from scratch and walk us through it.
Hi. All right, so some of you may be familiar with SharePoint, some of you may not. So let's get started here. What is SharePoint? Dictionary.com says there's no definition. So what we do know, though, is that SharePoint it helps manage documents in a secure way. What we can do with that then is we can share confidential information with the board members for possibly credentialing, or if there's discipline that needs to be taken against somebody, we can get that to you without just sending it necessarily through email, which, if there's an open records request, then it means that we have to get that information out. In short, what that means is it's just an all-in-one document management tool that we can use. It's also used by nearly 80% of Fortune 500 companies. So it's in wide use everywhere, and it's actually getting much stronger use in other places as well. What will you get out of it? Well, first thing you're going to get out of it will be important documents through or references for your board or council. They just may be all the materials that you're seeing today. They could be information just specific for how a board chair should run business, or different things like that. You may find your application and credential information that Carol Ann was talking about. You can also find screening panel information on there as well. Not every board has that yet, but it's coming down the pipe. You also find all of your agenda packets there. So any information that you need to run your meeting should be available to you on your SharePoint site. You will also be able to find your per diem and travel information, so that way you can get paid for your business here. Now, logging in is going to be the toughest part of getting on SharePoint, because there's two things needed to log in, other than the password that you normally need. A domain name, which is the computer that you're logging in from, essentially, and your username. Your username is going to be created by a bureau assistant if you don't already have one. Your password you can set yourself. The domain name is always going to be the same, though. So what you'll normally see, for me, is accounts and that name, which is my login name. But that's not going to get a board member in there. You are going to need to type in WIEXT and then the backslash, which means that slash is going to fall backwards to whatever it is that's in front of it there. You might see Tom's computer or work laptop on there. You might see accounts like I have. If you do see that up in that first login window, you're not going to get in no matter what password you type in. So use the option there to use another account. Once you type in what it is that you're looking for, you'll see right down at the bottom there it says domain, WIEXT. You can click on remember my credentials, and it should keep you logged in for most of your session. Okay, make sure that slash goes from top left to bottom right. Once you're logged in, you're going to find your shared documents. This is where you're going to find all the PowerPoints that we have set up here for you today. Your reference materials, your board travel reimbursement materials. All that information is going to be on that first splash page. Now, if you want to get more specific board materials, you'll have to click on either of the links that are available there that will say your board name. This is just a test site, board member training, so that way I didn't offend anybody by going into nursing or med or anything else. So you'll see medical examining board, you'll see nursing, you'll see land surveyor section, you'll see all sorts of different things on there, but only specific to the work that you do. If you're on more than one board, for instance, the section members should have access to all the different, so the section or the main board. As you're in here, you'll have all your different libraries, but at first you'll see your board materials. This is where all of your agendas will be. Okay? They should be labeled as such. You'll have a folder with the month and the day of the meeting, so that way you know what agenda you can go right into. You also then have all your different libraries on the side. Now that's where you're going to find, again, the board materials that you had previously. Your legal services and compliance link is there as well. You may not have anything in here, again, if your board hasn't gotten to that point yet. But you will eventually at some point get there. Credentialing is the same way. Board member folders, on the other hand, you should always have one of those. That's where you can specifically keep all of your board information. Now, all of your agendas will be saved there. You'll have an editable version of your board agenda That way you can make any changes to that. And those changes might look something like this. And then once you've made your changes, you can save that back up to the site so that way you have access to it during your board meetings. This is going to be gone over in a little bit more detail. I've got handouts that you can take on your way out. And all the Bureau assistants will be able to help you with this as well. If you need help from it, I'm also very knowledgeable on it too. But essentially, what you can do with this is you can set up bookmarks on the where it says A. You can do different types of annotations and comments. D right here will allow for you to click on whatever comment you've made, so you don't have to go through a 300-page document to try to find that one comment that you made about one specific thing. You can just click on the comment, and it takes you right there. Once you have made all your comments, you can save those back up then to the site. So you have to save it first to your computer. But if you click on the documents portion here, you'll see this brand new window pop up, or a new menu system pop up, and you have an upload document option right there. Once you upload that, you only have access to upload, by the way, to your own folder. You can't upload to somebody else's folder, so that way we don't break any of the open meetings law. But once you upload that, you have access to that through any of the laptops that you might have during any of your meetings, so that way you can reference all of your notes. You don't have to print out 20, 80, 30 pages of whatever agenda that you wanted to make a comment on. It's all right there. It's just as good as using paper and pencil, in my opinion. And that's about it for SharePoint. Any questions? Yes?
I know I've asked you this question before, Jeff, but this is machine specific, right? So if you have more than one machine,
That's right.
you have
So
to have one for each one.
the question is, if you have multiple computers, you have to log in separately for each one, and the domain name has to always be WIEXT. You may find on your laptop it says Joe's laptop. At work, it may say Joe's work computer or whatever it is named. And then on your iPad, it may just say Joe's iPad, in which case you have to change it on each one. So you do have to log in separately for each one. Yes?
I'm a state employee, so I've got an account name like you do.
That's right.
But I access, or I would access SharePoint from my personal computer at home. Is that account backslash going to work?
Yeah, you would still use the accounts so long as you're set up through SharePoint for using your accounts. So if you haven't been given a WIEXT extension, or domain, then yeah, still use accounts. I can log in from my home computer. I can log in from my phone using accounts, yes. Jim, did you have a question? Oh, okay. So Joe.
The other question is that's come up before, and I don't recall ever getting a clear answer on. Since this stuff technically resides, once we download it on our machine, wherever I am, does that mean that my machine is discoverable?
No. So these are, the machine isn't discoverable in do you mean by open meeting or open requests?
Open records.
That's a great question. I don't have an answer for you.
Yeah,
but I think Greg will write that down so we can get an answer for you.
We'll get back to that.
Yeah, because that was a concern that we had initially from day one. I don't want to call it, we ever went back and asked the question again to do it, because one of the concern, then it's there, and can somebody knock on my door and get my machine?
Yeah, we'll talk to all the legal people here. Get a good answer for you. Go ahead, Jim.
We have a meeting coming up in April,
That's right.
so should we be on SharePoint for that?
Yeah, I believe you do have a SharePoint account, but if you haven't accessed it yet, you may not
I have.
All right. In which case, your Bureau assistants will be able to help you get you logged into that. Now, you've been given, I believe, I set up your account, so you've been given an email with the information in there. But if you lost it, I can go back through and I can find that information. Logging in, again, is going to be your most difficult point. So once you get to that point, once we get you your information, if you have trouble, contact either your Bureau assistant or myself. I'm sorry?
I'm an old guy, I guarantee I will have.
We'll get you there, Joe.
We have access?
Are there any other questions about SharePoints? Looks like no. I think we're way out.
And you know what? I see Sarah Norberg lurking outside the door here. So I'm going to hand it over to Sarah. We're a little ahead of schedule.
I hear that. I think that everyone would want to get out of here a little early, so
I hand it
Talk
over.
another half an hour on case advisory training.
I can keep talking all day.
So if many of you, if you deal with business professions, probably know Sarah. She's one of our DLSC attorneys, and she's going to walk you through for the next hour or so and take some questions on what it means to be a case advisor. Do you need a microphone?
I don't think so. I'll try to speak loudly, just because I'm not sure I can hold that and do all of this. So if you can't hear me in the back, just shout out, to raise your hand, and I'll try to speak up. So, welcome. I know you've been here all day, so I will try to get through this as quickly as I can, but I do have a lot of information for you. Excuse me. And I'm suffering through a chest cold, so hopefully we'll make it through this. As Greg mentioned, my name is Sarah Norberg. I am a lead attorney in the Division of Legal Services and Compliance, and here to talk to you about your role as a case advisor on our disciplinary matters. So, first and foremost, the Division of Legal Services and Compliance is a part of the department tasked with the responsibility of enforcing licensee compliance with state laws and professional codes. We work collaboratively as the board's partner in ensuring that fair and just discipline is imposed on violators of professional rules in a way that accomplishes the state's goals of protection of the public, deterrence, and rehabilitation of the licensee. Within disciplinary actions, individual board members may have two roles. There's a judicial role of a final decision maker, a judge if you will, and the consultant role of a case advisor. And so most of my presentation will focus on the latter. As a consultant, the case advisor of a particular case assists the division's prosecutor with professional expertise on the licensee's misconduct and necessary discipline to bring the licensee into compliance. If the attorney and licensee reach an informal resolution, the board as a whole, including the case advisor, will hear relevant facts as the judge and determine whether the agreed upon resolution is sufficient. The consulting and judicial roles must be kept distinct and separate. To blur the line between those roles violates due process. So I will try to go through some of those issues a little later on in this presentation.
Please stand by.
Technical difficulties. The state of Wisconsin recognizes and respects an individual's interest in earning a living. However, that interest must be balanced with the public's interest in obtaining services that are safe and effective. So, as I mentioned previously, in disciplining licensees, the state has three goals: to protect the public, to deter the conduct, and to rehabilitate the licensee. The state does not punish licensees for misconduct, but provides them with the necessary tools and opportunities to regain compliance when possible. This protects both the public's and the individual's interests. I'm going to take you through the case handling process. The intake stage is the first stage in the intake process. When a complaint is received by the department from consumers, professionals, internal staff, we have intake staff who collects the relevant information, such as records, follow-up from the complainant, if the information is incomplete, a response from the licensee, and sends the complaint to the screening panel, which consists of a prosecuting attorney and members of the board. Usually, I believe you vote and you serve some time on the screening panel. The screening panel will meet at a predetermined time, usually once a month. Will confer and determine whether from the information provided a violation may have occurred. The panel may consider many factors such as the seriousness of the allegations, the harm or threat of harm, whether the dispute is already resolved, and whether the matter is primarily a civil matter or a private dispute. If a complaint does not warrant further action, it is closed and a closeout letter is sent to all of the parties. If a complaint does have merit or requires further investigation, the case is open and goes to the investigation stage. The intake stage is especially important as a gatekeeper against trivial complaints and cases without proof. This stage protects licensed professionals from meritless attacks on their reputation and livelihood. In certain circumstances, a licensee may be close to violating a professional standard, but didn't actually violate it. Through the screening process, the panel may choose to remind the licensee of the laws governing or potentially implicated by his or her particular activity in the closeout letter. So this is a little bit about what I talked about. Complaint is received, it goes to the screening panel, can either be closed or opened, and then we continue to the investigation stage. When a case is opened, a case advisor will be assigned along with the division legal team, which will be made up of an investigator, a paralegal, and a prosecuting attorney, and in the case of appraisers, a staff appraiser as well. The advisor can be assigned to a particular case by the screening panel. Sometimes in my experience, if the screening materials have been particularly thick and one of the board members already read those materials, they might volunteer to take the case. So it can happen that way. It can also happen on general rotation, where we just go down the line of board members who are to serve as case advisors. You know, one will get one, the next board member will get the next case. And that assists with even distribution of cases among the board members. Expertise might be a reason that we assign a particular case to a particular board member. In cases where professional expertise is not required, that's generally those types of cases we assign to the public members, so they can assist in this case advisor role as well. Geographical area might be a reason we assign a case. A case advisor is assigned based on not being in the same geographical area as the licensee, except in real estate appraiser cases. And finally, division staff can assign a case to a particular case advisor. This might come up if the case advisor who was assigned has a conflict. Once assigned, the advisor will receive an email or letter from intake staff with notification of the assignment. The notification will include the case number, the names of the parties, and a brief description of the complaint. At this time, the assigned advisor should determine if there is a conflict of interest or bias that would require reassignment. Conflicts of interest include, but are not limited to, a personal relationship with any of the parties in the matter, the complainant, the licensee, if we know there might be any witnesses at that time, or if you have a financial interest, relationship to a firm that's been pulled into the case, competitor, things of that nature. The case advisor must avoid any appearance of impropriety or conflict. And if a conflict does exist, or you're uncertain if one exists, please contact the division's legal staff as soon as possible. So the next stage in the case handling process is investigation. When an investigation commences, the case advisor may be asked to identify materials required in order to make a determination of whether a violation has occurred. During the course of the investigation, the case advisor is consulted to provide expert and technical advice and assistance to the division staff. At the conclusion of the investigation, staff will submit findings of the investigation to the case advisor. In complex cases, This might be a case summary that's drafted by the investigator, reviewed by the attorney, and sometimes might have a recommendation by the attorney already in it. In a simple case, this might just be an email with an analysis and summarization of the facts and the evidence. Your role at this point is to assist the attorney in determining what the professional standards are, if it's not already clear from the statutes and the code, whether the conduct fell below the minimum standards for the profession, and what appropriate discipline might be if a violation occurred. In cases requiring an opinion regarding the facts of the cases related to professional standards, division staff may require an opinion of the case advisor, who serves again in like a non-testifying expert role. While the prosecuting attorney is the expert of the law, the case advisor's opinion is critical on issues involving professional expertise. In straightforward cases, the division attorneys, as I mentioned, may provide a recommendation to the case advisor for approval. Where the evidence is insufficient to prove a violation by a preponderance of the evidence, which is our standard, it's a more likely than not standard, or there are other reasons not to pursue prosecution, the prosecutor and the case advisor, if necessary, will determine the specific basis for closing the case. If prosecution is warranted, division staff will work with the case advisor to determine appropriate discipline. Some considerations in determining discipline include historical practices of the board. We want to be consistent and follow precedent as much as we can. If you're new to the board, the legal staff can help you with this. We have the prior board orders, ability to search those orders, and might just have experience ourselves working with the board. We also are aware if this licensee has been disciplined by the board before. Another consideration would be the severity of the conduct, including the risk of potential harm, and the quality of the evidence with which the prosecutor should be able to aid you with. Also, because the legal team has direct interactions with the licensees, the team may have important insight as to what may be the most efficient and effective way to bring a particular licensee into compliance. But again, discipline cannot be punitive and is limited to actions taken on the license for purposes of protecting the public, deterring the conduct, and rehabilitating the licensee. The end goal is for the attorney and the case advisor to agree on appropriate resolution for the case. Discipline is appropriate for licensees who fall below the standard of minimal competency. The state does not regulate professionals to all operate at the highest standard possible, which is a system better controlled by the market and the individual professional's reputation. Instead, we regulate professionals to operate at the minimum standard. At times, licensees may be careless, incompetent, or reckless. As the embodiment of the profession, boards must make sure that the imposed discipline is appropriate to address the misconduct when the entire circumstances are taken into account. In addition to formal discipline, boards also have non-disciplinary options that may more appropriately correct the licensee's failure. The case must always be reviewed and determined on a case-by-case basis, taking into account all facts specific to the particular case. Some useful non-disciplinary tools are when the incident in question was not seriously harmful to the public. The legal team, including the case advisor, have ability to close cases for what we call prosecutorial discretion. Sometimes the simple act of opening a case and making the licensee aware is enough to bring them into compliance, which is the second one here. Another reason that we might close a case for prosecutorial discretion is when there is litigation, civil litigation primarily pending, which affects our ability to investigate the case. So we have the ability to kind of close that case out, but flag it so that when the civil litigation is concluded, we can take another look. Another form of non-disciplinary action is remedial education. This requires the licensee to complete education that addresses his or her failure through a board order that does not include a specific finding of a violation. This allows the licensee to gain compliance with less embarrassment to his or her professional pride, wouldn't affect practice privileges, but it is published on our website. Another form would be an administrative warning. This requires that the misconduct is a minor violation and a first occurrence of this violation for the licensee. The fact that the warning was issued is a public record, but the content of the warning is private and confidential. Licensees have the ability to request a review of the warning within 20 days, and they'd be able to make an appearance before you and your board. If the warning is appealed, the board may re-examine the case and request the division to pursue a different path. An administrative warning, while not discipline, may be used in a subsequent disciplinary proceeding as evidence of knowledge of the misconduct. I think this is the final non-disciplinary tool, the professional assistance procedure. PAP is an alternative to the formal disciplinary process for impaired professionals. It encourages individuals to seek help for their impairment in a non-disciplinary environment. If an individual is released from PAP for failure to comply with the program, the department monitor may at that time refer the individual to the division for disciplinary proceedings. Now we're on to formal discipline. If the licensee's misconduct cannot be corrected with a non-disciplinary option, or if the misconduct is common enough that all licensees within the profession must be alerted to its substandard nature, formal discipline is warranted. The lowest level of formal discipline that we have available to us is a reprimand, to publicly warn the holder of a credential. Along with a reprimand, we may limit the individual's license. So a limited license means to impose conditions and requirements upon the holder of the credential and to restrict the scope of the holder's practice. A credential can be limited in many ways, allowing boards to creatively and most appropriately address the credential holder's deficiency. For example, you can limit a license with education. Would that meet the purposes of disciplining, which are, to protect the public, but also to rehabilitate the licensee? So if a licensee appears to have violated a rule based on a specific area of the law that they might just not have enough knowledge, you can order them to complete a certain amount of education on a specific or one or more topics within a certain time frame. Along those same lines, maybe they need to take another national exam or a state exam or whatever types of testing are involved in your profession's license. Assessment and treatment may be another way to limit the license. Supervision, work reports, or auditing might also be considered. The license limitations are somewhat endless. You can limit by practice scope, geographic area, types of procedures, types of clients. As I mentioned, they can be for a certain time period. We just want to make sure that we are drafting an order that is measurable. Can what we want them to do be measured and monitored so that if they're not in compliance, we can take additional action? And just a note, we cannot order restitution, charity work, anything like that. We have we've got to have clear statutory authority for the discipline we're imposing. Moving up on the chain of formal discipline to something a little more harsh would be a suspension. To completely and absolutely withdraw and withhold for a period of time all rights, privileges, and authority previously conferred by the credential. Suspension should only be used when the conduct was egregious, as it is a form of deterrence rather than rehabilitation. Suspensions can be imposed by length of time, completion of other board requirements, and we can require them to petition the board to lift the suspension after a certain time frame or certain requirements. The highest level of formal discipline is a revocation. Sometimes we can do it in the form of a voluntary surrender as well. This is to revoke, to revoke is to completely and absolutely terminate the credential and all rights, privileges, and authority previously conferred by the credential. Again, it's only for the most serious misconduct. Now, this might seem contrary to what I just said, that it may or may not be permanent, but sometimes we might feel that they should be out of practice for 2 years, 4 years, and then be allowed to reapply. So whether it be a revocation or a surrender, if they're allowed to reapply, they would need to meet all then existing requirements for initial licensure. So whatever initial education or testing needed to be completed to get a license will need to be completed again. A surrender, it's the same thing, it just generally causes less embarrassment. Then there's a voluntary surrender or a retirement surrender. This might be where a disciplinary matter has been opened and the licensee is near retirement or has decided to pursue another profession and just wishes to stop practicing. We can do these without a formal finding of a violation because these will be permanent. No reapplication here. This isn't moving up the chain of levels of discipline, but some boards have forfeiture or citation authority. I'm not sure I'm aware of a board other than the cosmetology examining board that has citation authority, but a lot of boards and sections have forfeiture authority. Needs to be within the statute. Another option that we have available to us is a summary suspension. Summary suspension is a special tool that allows us to suspend a licensee without a stipulated agreement and before a full hearing is had. Because this tool circumvents due process, it can be used only when the facts establish that the licensee has engaged in and or is likely to engage in conduct that threatens the health, safety, or welfare of the public, which requires emergency suspension. If a board uses summary suspension, a formal complaint must be filed very shortly after that order goes into effect, and the hearing on that must be held promptly. So if the legal team and the case advisor think this is appropriate, you pretty much need to make sure that you've got all your evidence because very quickly thereafter you're going to be going for a full hearing. Obtaining a summary suspension against a licensee does not necessarily mean that that licensee has indeed engaged in misconduct. It only means that we have enough reason to believe he or she did and that they will continue to do so, placing the public in danger. Without evidence that the dangerous conduct is likely to continue unless the licensee is suspended, summary suspension should not be granted. Moving to the next phase of the case handling process is legal action. Disciplinary action may be agreed to by the licensee in a stipulation, and if no stipulation can be reached, discipline can be pursued through the formal hearing process. So, negotiation. We generally negotiate or try to negotiate a stipulation, a settlement, if you will. It's a proposed agreement between the prosecuting attorney and licensee as to the resolution of the case, and it is subject always to board approval. The division legal staff will consult with the case advisor on a specific settlement offer or a range of appropriate discipline or bottom line offer that is acceptable. By entering into a stipulation, a licensee will be waiving certain rights, including the right to a hearing on the issues. The negotiation process often involves a give and take between the prosecutor and licensee, or the licensee's attorney if they have one, and not every case will end in a stipulation, although I think, just as in civil practice, most do. So if we can't achieve resolution through a settlement, we'll be moving on to hearing. A formal complaint will be filed, and an administrative law judge with the Department of Administration's Division of Hearings and Appeals will be assigned to hear the case. The licensee is given an opportunity to file an answer to the complaint. A hearing date will be set, maybe a few months out, allowing the parties to engage in discovery. It really tracks the civil process. It's just much less formal. The case may still be resolved through a stipulation even after a formal complaint has been filed. If no agreement is reached, then the case actually goes before an administrative law judge at hearing, which is held here at the department. At which time the prosecutor and the licensee or their attorney may present evidence, which includes witnesses and documents in support of their position. The division has the burden of proving by a preponderance of the evidence that a violation of rule or statute occurred. And again, that just means a more likely than not standard. Following the hearing, the administrative law judge will prepare a proposed decision, which is submitted to the board for consideration. So the boards have delegated this fact-finding to the ALJ, but it is ultimately up to the board to decide what should happen with the case. The board will consider the record in the case and issue a final decision in order. The board can either accept the proposed decision of the ALJ, it can reject it, or it can alter it by drafting an amended decision called a variance. There are different appeal rights as well with this. A licensee who's been disciplined after a final order of the board can petition for a rehearing, or actually has some civil court appeal rights, can petition for judicial review to a circuit court. The most important factor in ensuring efficient and effective discipline of a licensee is clear communication between the case advisor and the legal team. The case advisor and legal team assigned to the case should maintain open communication, telephone, fax, email. Just let the legal team know whatever works best for you. And it's an ongoing process throughout the case. The case advisor should provide the legal team with an opinion or request for additional information within 2 weeks of receiving the investigative materials, 3 days for real estate appraisers. The federal government mandates that real estate appraiser cases be resolved within a 1-year time frame from the date the complaint is received, so those need to be handled much more quickly. Timeliness is obviously critical for many reasons. It allows us to conduct an investigation, collect evidence that might be fresh. Licensees obviously want to have their cases resolved as soon as possible. So if the case advisor knows that there might be a delay, you're really busy at work, you're going to be out of the country, please let the legal team know as soon as possible. Confidentiality. Being privy to private and some oftentimes unproven information, the case advisor has the duty to maintain confidentiality. Pending cases cannot be discussed with other board members, colleagues, or friends. Occasionally, an issue may arise that is outside of the certain advisor's specialty or area of expertise. In those circumstances, the advisor may consult with a colleague in that particular field or specialty in order to form an opinion on the violation and appropriate discipline. However, there's two prohibitions on this. The consultation may not be with another member of the board. And specific information in the case may not be disclosed. If questions or other concerns arise, don't hesitate, again, to contact your legal team. Ex parte communications. Case advisors must not communicate with individuals involved in a pending case, including the complainant, licensee, any witnesses, because you're acting as, again, this goes back to the dual role, acting as a judge, acting as a non-testifying expert. It's essential that all decisions and recommendations be made with objectivity. So there, you must protect against conflicts of interest as well as the perception of a conflict. Let me back up 1 second. So we've had this actually happen. If a party to a case, the licensee particularly, attempts to contact you, you have to let them know that you cannot discuss any matters with regard to the case with them, and let the prosecutor know right away. When a proposed resolution, whether a result of a stipulated agreement by the licensee or a proposed decision by the ALJ is before the board member that served as the advisor for the case may or may not be a part of the deliberation and vote, depending on what type of case it is. With proposed stipulations, administrative warnings, or case closures, the case advisor may participate in discussions and may vote on the matter. In fact, the case advisor should be prepared to speak in support of the agreed upon resolution, discipline, or closure. The advisor can always contact the legal team, kind of to refresh your memory if it's been a while since you spoke with the legal team and by the time it's actually getting to the board. Proposed decisions following an evidentiary hearing, this is the hearing before the administrative law judge, you may not participate in discussions or vote on the matter because you likely had access to information that may or may not have been presented, that may or may not have been admitted as evidence during the hearing, and it would be unfair and unjust to the licensee for the advisor to report on things that weren't proven at the hearing. Another special note is case advisors may also need to abstain from deliberations and voting in probable cause determinations. I think that's the medical examining board only, and also summary suspension determinations. All materials you receive during the course of the case, investigation, and disposition are confidential. They should be kept in a secure location and not shared with others. When the case is closed, you may destroy all copies or return them to the division for disposal. I think it's unlikely, but if you think you were provided an original, please make sure that that gets returned to the division. And I just buzzed through that. We want to thank you all. You are just so necessary to the resolution of these cases. Again, we kind of know the legal side of things, but you all are the experts in your own field, and without you, we couldn't do it. So we want to thank you for your commitment to the profession and for your service on the boards.
Any questions for Sarah?
I know that was really a lot of information very quickly. Joe.
Sarah, do you ever see an instance where, because of the nature of a case or situation, where the case advisor recommends the inclusion of an outside expert on this stuff because it may not be in an area that they are familiar with or that they practice?
Yes, and so that goes back to I don't know why, but we refer to it internally as the curbside consult. So if you're not insight and understanding you. But this would be where you feel that the issue involved in the case is not really within, I mean, it's within your profession, obviously, but maybe not within your area of expertise.
Right.
You are free to, if you know a colleague or a friend in the profession or someone else, you're able to discuss the issue, just nothing specific, and it can't be another board member. In cases that are, very technically difficult, if we have to go to hearing, you've generally served as the non-testifying expert. We will generally be hiring a testifying expert if need be to go to hearing. Did that answer?
No, that's exactly what I was looking for, because I would think also that a person, because I've been in the case where it does something like that and asks somebody else some questions like that, I should be with the knowledge of the legal team so they know what's going on in this.
Absolutely.
Because something can get downright nasty and dirty and something, so I'm not blindsided.
Right.
The case advisor would never be called as a witness, right, in a hearing, or is that?
No, I don't think so. Because you're kind of part of the legal team.
Well, that's what I thought. So, thank
So
you.
you're safe there.
That day.
That day.
Could you give an example or two of when a summary suspension has been issued?
Sure, I just had one last month. My first one here. The case involved it was a real estate case, and I actually was part of the screening panel, so I saw it very early on. The allegations were theft of large amounts of money from a client in the realm of the licensee's real estate practice. So I was kind of alerted that this might be the way we have to go very early on. So the case was opened at screening. Case advisor was assigned. I discussed it with the case advisor. He agreed, and we very quickly got that investigation underway, and I filed a petition for summary suspension. It's kind of, again, like the civil process or the administrative hearing process, where I didn't file a complaint, but I filed a petition for summary suspension with supporting documents, affidavits, things of that nature. And that goes to the board as the judge. And I was afforded the opportunity to make a presentation to present my case. The licensee was given notice. They can appear. I don't believe they're generally allowed to present a full case, but to make a statement. In my circumstance, he did not appear. And I think we were very concerned because perhaps a large amount of money had been stolen, that the public was at large risk of him, and he's still practicing, so he could do it again. So the board did grant the summary suspension. There are appeal rights to a summary suspension, too, which I didn't mention. I hate to get too far down the line for all of you, but they can request an order to show cause, or in order to show cause, which a hearing would be held. Basically what that means is we want the prosecutor to prove why this summary suspension should continue until the full hearing is had. But by the time this gentleman actually filed that, I had already filed my formal complaint. So now it's kind of interesting because we're heading down the formal path to the formal hearing, and then we might have this other thing. So depending on which goes first, might be a moot point.
It sounds like in that case there will also be, there could also be some criminal action too.
Which there is. So I had discussions with the county district attorney handling that case. Wanted, just like, as I mentioned with civil matters, our ability to investigate may be impaired by civil matters. I wanted to make sure I wasn't going to mess his case up, his criminal case, with our ongoings, but it was all fine. So that person is facing felony charges as well.
So with the summary suspension, is a public notice? I mean, is it on the website that the individual's license is? Okay.
And so is it open? Is it open session except for the voting and deliberations?
credential holder, it would be suspended.
It's suspended.
Sarah, can you walk me through, I had a case where violation there, and is there a statute of limitations? However, I guess I'm talking about the historical being consistent on the reprimand. How far back can you go, and what's, can you walk me through the process? I was trying to, has this occurrence happened before where the fine, reprimand to be consistent from year to year?
With one particular individual, or just with the board's decision as a whole?
I mean, you want to be consistent. If pharmacist did this, shouldn't it be the same fine? Be so we're consistent and
right.
not reinventing the wheel, maybe?
I think we can go back as far as the board has orders. Consistency is something we strive for, but we also have to balance it with every case. The facts and circumstances of every case are different. There might be mitigating factors, aggravating factors. So we can go back, but something that also needs to be considered is the change in the makeup of the board over the years, and the board's stance at different times. So I think it's up to the legal team on that particular case. I generally, personally, I prefer not to go back too far, maybe the last 5 years. Is that fair?
Yeah, I'm trying to check, we're relatively new, all of us, and trying to get a handle on, you're dealing with lives and, careers and
right.
struggling to do the right thing, I guess.
Yeah.
To piggyback on that just briefly is that because we're not allowed to speak to other board members about a pending case, it's maybe direction on how boards in the past have tried to have more generalized discussions around maybe something like the concept of just culture or other, so that we have a sense of where we're at for different types of discipline that might come through, so that we don't get to the point where there's a stipulation agreed upon, and then it comes to the board, and then the board says, oh, we were either too lenient or too harsh, and then we have to kind of undo all of that, I guess.
Right. And hopefully the staff in the division can really help you find out what the board has done historically, as well as give you the understanding for why you might be doing something that isn't consistent with what the board has done before. Just because you can't discuss the specific issues of a particular case with the board, you certainly as a group can discuss how you feel about certain activity. I know I've seen lots of times new developments in the profession, with this Great Recession, particularly in real estate. Now there's a lot of REOs and foreclosures and short sales, and real estate professionals not marketing those, but helping banks make sure the pipes don't burst and things like that. And if they put a sign in the window, is that advertising when they don't have a listing? So new things develop in the profession too that need to be discussed by the board, and a determination made on how we're going to deal with those new violations. So I think I got off of your question, but.
Well, I think you answered it. I think if there's more, when we have some more prospective discussion globally, we get a sense of where we feel is that minimum competence or what that minimum standard is, so that when cases come through, we don't get to the point where we want to have to go back and reopen and change stipulations that are.
Yeah, because you're in a closed session for a real short time, you're trying to deliberate and make a sound decision.
Right. It is challenging.
I just had a question of clarification. Did you say that under the circumstance of surrender, they can never get their license back?
Well, that's part of the negotiation. So sometimes they can, and sometimes they can't. Lots of different factors play into that. If the violations were so egregious, or this person just seems too incompetent, we may not want to allow them to come back. So it might be a revocation or a permanent surrender. But sometimes, I'm just trying to think of a circumstance, sometimes you just don't want to take it away forever. So they might surrender for 2 years or 4 years, but long enough where they have to then come back and meet all the initial licensure requirements, like education, testing, things of that nature.
But then it's written into a stipulation. If somebody just turns in their license because they say they're never going to practice in the state of Wisconsin again, there's no stipulation.
They can't resolve a disciplinary case by coming into the department and handing us their license. Can't do it. Has to be an order. It has to be an order approved by the board.
Thank you.
What if they beat someone to the punch and they come in and voluntarily surrender their license, and then there's a complaint that comes up? Aren't they outside of the jurisdiction of the department at that point? If they say they're no longer practicing?
You know, I've never encountered that circumstance. I was thinking where they might, maybe a complaint was filed, they know the complaint was filed, and then they come in before the disciplinary action really gets underway. And I believe the individuals in our credentialing, we all have access to the same system and the same database. They would, the people in credentialing would be able to see that they had an open disciplinary matter and would probably alert someone in legal services and compliance and might not let them do that. We still have the ability, particularly if the license is expired, you know, you have a 5-year automatic right to renew upon payment of a fee. So even if they have an expired license, we can still discipline their right to renew and actually put orders out, limitations on that. I mean, I've not thought of that, I've not seen that firsthand.
There are some employers that will say, either you resign or you're fired, and they'll choose to resign. I mean, if they,
right.
I doubt it would happen very often, but.
I guess I'd like some clarification as a citizen on that examination board. If I'm assigned a case that's not technical, and you were discussing with the individual here about.
Can you speak up a little bit?
And you were discussing with the individual up here about, if we can't discuss, you say if I assign a case and it's not technical to the veterinary issue, and I can't discuss it with other board members, you had suggested that on a general basis, you know, in talking with the legal team and or talking with, I'm a dairy producer, so I have access to other veterinarians. Am I free to discuss generalities to get a feel of, say, for example, impropriety or?
Sure. As long as you're not revealing any confidential information about the specific licensee, anything that you're privy to that you would know is confidential, you certainly can. Anybody else?
Does DSPS have any jurisdiction over people practicing professionally on the internet with Wisconsin residents?
I think it would depend on the board and what the board's statutes and regulations say. The example that comes to my mind, and I work on the non-health related cases, would be auctioneers. Some auctioneers conduct auctions live on the web. So the board interprets the definition of auctioneering to include that, even though it's not live at an estate, it's on the web. So it just depends on your profession, statutes, and regulations. Anybody else? Thank you so much. I know it's probably been a long day, and it's Friday afternoon, so thank you so much for your time.